Hi, I'm Julian Nacol. I'm here on behalf of Nacol Law Firm. Today we're going to be talking about deceptive trade practices, most commonly known as DTPA. Now, before I get into this, I need to state that the deceptive trade practices, the damages that you can receive by pleading this and successfully pleading it for a trier of fact or a judge, are tremendous. There's a lot of teeth in the damages you can receive on this. The reason for that is the Texas legislature wanted to protect the consumer. This is the Consumer Protection Act. Now, when I say by teeth, I mean you can receive attorney's fees, you can receive actual damages. Furthermore, you can receive, it's a high burden, but if you can prove there was mental anguish, you can receive damages for that as well. So there's a lot of teeth in this. But to get that bite going, you have to follow certain procedural safeguards. Well, not safeguards, but procedurally, there's certain things you have to do. One is the 60-day notice. Now, a lot of lawyers just agree to do a boilerplate 60-day notice to the opposing side, and then they answer it, and that's that. In the Nacol Law Firm, we take it seriously because the 60-day notice and demand letter is one of the central and most important parts of pursuing a deceptive trade practices claim. Now, the demand letter has to state all your damages, what you're alleging, what you're claiming, and they're going to have to respond to that within 60 days. If they don't, there's the potential of waiving any kind of limitations they can put on your damages. Not only does it state the tempo of the litigation, but it also will help mold whatever kind of mediated agreement you might perchance have the ability to obtain in the case. It's very important. So deceptive trade practices applies to consumers. Most of these cases are going to involve buying a car from a used car lot, purchasing a home, or getting a general contractor that just did a horrible job on your house. In the Nacol Law Firm, most of the cases we receive and calls we receive regards to residence, the residence itself. So you buy a home and the plumbing's horrible, or you buy a home and the roof falls in and there's leaks everywhere when in the first time it starts to rain. Now, if we can prove intent, hold on, because we got ourselves a very good case. And when you get a demand letter from Nacol Law Firm, you're going to respond in a way that is probably going to inhibit any further litigation. Purchasing a residence in and of itself, that is a very big claim, and it's important because of this. For most written contracts with the DTPA, there's a limitation for this statute for up to $100,000. Now, if there's no contract, it's $500,000. But for a residence, there is no limitation. So if it's your personal residence and you buy a $500,000 or $600,000 home, and the first time a rainstorm happens and your roof starts leaking everywhere, and you give us a call, they're going to get a 3 to 4 page demand letter, and they're not going to be a happy camper. So certain other things to know about deceptive trade practices: 2-year statute of limitation, so you have to jump on it when you find that the problem occurred. Furthermore, it is extremely hard to waive deceptive trade practices. If a person wants you to waive it, it has to be identified in the written agreement, and another lawyer has to look at it. So overall, deceptive trade practices has a lot of teeth. It's important to find someone to know what they're doing for the 60-day notice and demand. Give us a call. Nacol Law Firm, 972-690-3333, or take a look at our blogs at nacollawfirm.com. Thank you.